to go.
Okay, I'd just like to call the meeting of the Law, Building, and Code Enforcement Committee to order for the April 26th meeting. And to start off this meeting, Mayor Sheehan is with us, and this is her initiative. And I want to start off with her and let her tell us what this is all about.
Thank you so much. I appreciate the opportunity. I appreciate the council taking up this legislation. You know, as I often say, our goal is to create in Albany a city where every neighborhood works. And part of a neighborhood working is that it have quality housing that's affordable to the people who live in that neighborhood. And so while we know that many of our landlords strive to do the right thing, they treat their property as they would treat their own, and they respect the rules of the road with respect to the maintenance of that property. We also have a number of challenges in our city. And, you know, we first started to address the issues of vacant and abandoned buildings really on day one when I became mayor. It's been a long journey. But one of the things that we've learned through, you know, starting with the Public Arts Challenge that we were successful in winning from Bloomberg in 2016, that then led to $1 million in funding for rehabilitating vacant and abandoned buildings that we launched in 2017, to being successful in getting funding from the New York State Attorney General's office to fund the position of a neighborhood stabilization coordinator, because we realized that it was nobody's job that to focus solely on our vacant and abandoned buildings in the city. We changed the way that our our fire department inspects those buildings. You know, we've made a tremendous amount of progress, and yet we continue to have blight in the city. In 2019, we partnered with Bloomberg Philanthropies again and Harvard University to really look at innovative solutions. And one of the things that we determined is that we need to look downstream. We need to, or upstream, I always get that wrong, but we need to ensure that before a building becomes vacant, what leads to that vacancy? And so we started to think about all of the things that lead to a building ultimately potentially going vacant, and the decline that can happen in certain communities when landlords don't invest in their properties. In January of 2020, we were awarded $1 million, again from the New York State Attorney General's office, Letitia James, to implement the innovative strategies that arose out of that program that we did with Bloomberg Harvard. And those initiatives included you know, funding to hire another codes attorney, funding to hire a housing services advocate, creating a mow-to-own program, a deep dive block program, creating a good neighborhood school, also an estate planning program, because we learned that a number of our vacancies happen because of estate failure to plan in those instances. And we also are undertaking proactive demolitions. And so while that program was delayed in 2020 because of COVID, we haven't deterred from executing on the transformative initiatives. And that's what led us to where we are today. Today, the Common Council is going to begin reviewing a package of historic fair housing legislation that we introduced several weeks ago, and that will empower our codes department to proactively address building emergencies, modernize our rental dwelling registry, and create the first good cause eviction law in New York State. Our city's RISE team spent months surveying landlords and tenants, holding targeted community discussions, completing extensive research into what other municipalities across the state and across the country were doing to combat housing blight and the housing crisis. And we also worked with a number of Common Council members. And so the proposals that you're going to be considering are designed to create transformative fair housing rules that will further stabilize city neighborhoods by providing landlords, tenants, and the city the tools that we need to secure and provide quality housing in our capital city. This legislation has been become even more timely as we are dealing with the housing crisis created by COVID-19, and as that crisis and the impact of it becomes more widespread. The changes are designed to improve the relationship between tenants and landlords. It's also designed to ensure that our codes department has the tools that they need to work with landlords. We're going to be able to inspect rental properties every 2 years instead of every 2.5 years, which was not the most conducive time frame anyway. It will also, which will help us to catch issues. This legislation also allows ROPs to be revoked if there are multiple code issues or serious code violations. We know that we have code inspectors who oftentimes are torn between declaring a property unsafe and unfit and trying to keep a family in a building. This legislation allows us to address that in a more proactive way, undertaking those repairs in order to keep families housed. And I want to stress that the proposed good cause eviction, it really just codifies nearly a dozen common sense grounds for eviction that are already considered by our courts. That includes being able to be evicted for failing to pay rent, for substantive lease violations, unreasonable refusal to allow the landlord to enter a premises, illegal use of a unit, nuisance, criminal or illegal activity. So this is not, as some have said, de facto rent control. This is a way for us to ensure that we are creating those neighborhoods where there is quality housing that is affordable to the people who live in them. And I want to thank our city's RISE team for all of the work that they've done on this legislation. I know that they stand ready to answer your questions and concerns. I want to thank all of the organizations that we worked with to get to where we are today. And I look forward to working with the Common Council, our residents, and our landlords to move this legislation forward. Again, thank you for giving me the opportunity to speak at your meeting.
Thank you, Mayor.
I'm sorry, Mr. Chair. Did you want to go back and do attendance? I think we may have
Yes,
missed the members of the committee that are present.
Yes, I believe the whole committee is present right now, being, let me see, myself, Michael O'Brien, Ginny Farrell, Owusu Anane, and Sonia Frederick. So all present from the council, so we can do what we need to do. And then if we could start with the people from the city administration that worked so hard on putting a lot of this legislation together. I believe they're all here. Rob McGee, I see Rick LaJoy. Is that it?
We have
Laura Golfo.
Laura Golfo.
Okay, I didn't say that. So why don't we go ahead and which one of those people want to go first? Who, Rob McGee, maybe?
Yeah, sure. Sorry, had a little difficulty unmuting there. I don't know if the committee has particular questions about any particular aspect of the legislation, but I can give a brief overview of the changes to the residential occupancy permit portion of the rules, and I think Laura and Rick can help me out with that, but then Laura can cover the good cause, and then maybe Rick can talk a little bit about some of the changes to the emergency powers that his position would have. So with the residential occupancy permit changes, I mean, we're not looking at anything major here. Let me just pull my notes. So the period for which a residential occupancy permit will be active is going to go. Is going to be changed to 2 years from 2.5 years. That's going to give the building department more opportunities to actually inspect a building, make sure that there aren't code violations that are developing in the interim. The fee is going to stay the same, but there will be what is essentially a late fee or a kind of a first-time ROP fee. So an ROP is in those cases where you've had an expired ROP for, or it's a new unit. The initial ROP is going to be a $50 fee as opposed to a $100 fee. There is going to be a requirement that the residential occupancy permit be posted at the property at a conspicuous place. It's going to include some information in there that we think is going to be valuable to code enforcement and to tenants and to landlords, which we think is going to facilitate more open communication among all of those parties so that we can do more informal enforcement. And also in the event of an emergency, it makes it easier to reach a building owner so that we can, again, try to resolve things informally without having to use notices of violation and pursue fines and that kind of thing. And then we have in the new proposal provisions whereby an ROP may be revoked in instances where there are substantial code violations and there's been, essentially willful failure not to comply with the notice of violation. And there, I can go into the details of this, but there are set factors that apply where, as long as the landlord is making an effort that the ROP would be maintained, so long as the violations are cleared in a short period of time. And like the mayor mentioned, these changes came out of, a number of conversations that we had with the community over the course of probably a year and a half. And we think, these are necessary updates to our ROP law, which is really a model statewide and which has worked well for several years, but does need to be updated. So we look forward to passing those. And again, I'm happy to answer any more specific questions about ROPs or any of this, but at this point, I'll pass it over to Ms. Gulfo to talk about the good cause portion of the proposal.
All right, thanks, Rob, and thank you, council members, for inviting us to speak on this. This is something that we're obviously excited about. I know, as the mayor mentioned, on good cause, the way that I think about the good cause and the proposed changes is we're really just putting the tenants and landlords on notice of what is an acceptable cause for eviction. Landlords right now have to take their tenants to court to evict them. And more often than not, and what I've heard and just having friends who also practice landlord tenant law, no, I'm not aware of a judge who would sign a warrant for eviction without some sort of purpose behind it. And this will put both sides on notice of what those purposes and what those codified purposes are. For us also, good cause eviction, it would help to stabilize neighborhoods, which in turn could increase property value. So that's another thing to think about when you're considering these changes. Happy to continue the conversation, but those are sort of the broad strokes of what we're thinking with good cause.
Okay.
And then, another component of this is going to be sort of an expansion of the emergency powers that Director LaJoy is going to have with the building department. And I'll let him speak to some of those.
Yep. So this portion of the legislation is like Rob said, is an extension of the powers we use currently for emergency stabilizations or demolitions. And what this would look like in our day-to-day would be in lieu of displacing tenants. We often have to displace tenants for no heat, no power. And there are a handful of landlords that will use these types of instances for a quick eviction in their mind. They'll cut the power, or they'll not fix a hot water heater, knowing that we'd be obligated to displace a tenant. So in lieu of displacement, we would have the ability to make that repair and bill the owner for it and hold the tenants in place.
Okay.
Yeah, that covers them. I know there's several other housekeeping provisions in the law that are sort of technical, so we can talk about those. But yeah, I mean, I think that provides a pretty good overview of what the proposal is.
Now, my concern is you guys drafted this legislation. I just want to make sure that the sponsors are that familiar with it to answer the questions, or at some point in time, we're going to have to get you back in. Okay, so Mike O'Brien has his hand up now.
Ms. O'Shea had her hand up.
Oh, I don't see it. Well, you take care of that, Jay, all right? Whoever had it up first. I can't see on that screen.
It was
Cus-
Judy first.
Yeah, custom is that generally committee members would ask questions first, but I'm glad to go if you.
Well,
however you guys want to handle it.
that is why I started off, to see if they were, how we want to do this, okay? Why these gentlemen are here now, ladies and gentlemen, to answer questions that drafted it. And if the sponsors are comfortable enough to answer them, and then which one do we start with first? Okay? Do you want to just?
Michael, can we just go down the line with like local law H, and then if anyone have questions, because I feel like we're all over the place right now, or whatever law is first, and we just ask questions for that, or
Well,
I would rather
my
not
question
do it that
kind of
way.
applies to all of them.
all of them? Okay.
Yeah.
I also have a quick question as well.
It's not open for public comment yet. The questions are being asked by the Common Council committee members first, and then we'll go to the public comment period. So, Mr. Chair, would you like to start with O'Brien first as a committee member, and then we'll go with the,
Yeah, so
non-committee
Dr.
members?
Fahey and Jimmy Farrell are the hands that I see up right now.
okay.
Okay. My question is, in 2019, the New York State Legislature passed a Landlord Tenants Act, which was probably a once every 4 or 5 decade type of thing. And it was very meant to be very pro-tenant. And I got to say, I'm not super familiar with it. I know I did a little bit of volunteering with legal aid and veterans and went into landlord tenant proceedings a handful of times, but that was prior to 2019. But things that kind of come to my mind is I read some of this, like the one that dictates what percentage of rental increase can be as rent control. And maybe it's needed. I'm not arguing that. But do we have the authority to do that? Because I always saw rent control as something that had to be passed by the state legislature for a given locality. And then they had a whole, as I understand it, rent control board that oversaw the process. We're not asking for that in this legislation that I can tell. So I guess I have a question, and this would be answered by Rob, probably. Maybe we should get an update of what the current status of the law is after the 2019 major renovation of New York State law. And then, you know, I guess we have, maybe that would answer a lot of future questions ahead of time. So that's the point that I would like to make now. Educate us a little bit about what the status of the law is under this big reform act that came out in 2019, how we're improving upon that, and are we even legally able to improve upon it with the idea of rent control and I mean, right now, as I understand it, if I were a landlord and I had a niece who wanted an apartment and the lease expired or there never was a lease, I could actually evict that person and bring my niece in as a new tenant. But apparently that's something that is going to be forbidden unless you're 4 apartments or less by this. I just give that as an example. It's probably not so common in terms of the problems which you're trying to solve. And then the other thing is with ROPs, the little bit that I learned with the little bit of work I did with veterans who were homeless was that even if a place didn't have, first of all, a hell of a lot of places wound up without ROPs current. And that didn't make any difference to the court, Albany City Court, with regard to whether the place was habitable or not habitable. If you were trying to make a case that for withholding rent, just the fact it didn't have an ROP, the city court judges that we appeared in front of didn't equate the two. No ROP, not habitable. Therefore, you can withhold rent to have a repair done. So those are some of my questions now, which I think Rob could probably answer. And they probably apply to more than just one of these local laws.
Yeah, I think we can kind of break your questions up into a few. But as far as the state, the new state package, I think Ms. Gulfo can actually speak to that better than I could. But then once she's talked about that, I can talk about why I believe we have the authority to pass this law. If you want to start, Laura.
Sure. Yes, Councilmember O'Brien. So we did kind of anticipate this question because it was such historic legislation that was passed by the state, and not to discredit that by any means, because that was very all-encompassing. The way that I see this legislation being different than the state's legislation is that the state never opined on good cause or any type of cause for the eviction. So that's the biggest difference in my perspective. The state legislation did build in certain like, I don't want to call it delaying tactics, but like noticing requirements that a landlord would have to give to a tenant in order to pursue the eviction. But the actual cause of the eviction had not been addressed. And that's what we seek to bridge that gap with this.
Yeah, in terms of the, why we believe that the Common Council has or we as a city have the authority to put this out is because, in order for a state law to preempt a local, a local authority's ability to pass a law, they have to occupy the entire field. And it's our position that the law as it exists now does not occupy the entire field of the landlord-tenant relationship. And that bears out just historically in local courts recognizing, local laws and ordinances as being a factor that comes into play in landlord-tenant proceedings. And that kind of leads into the point you're making about ROPs. I mean, my understanding of housing court, of our city court now, is that they do prohibit, or they will not move forward with a non-payment proceeding if there is no ROP for a property. And one of the things that this law does is actually it requires with the filing of the eviction petition a copy of the ROP, so that question is answered up front, and that we're hoping is going to save some time in eviction proceedings by, again, resolving that question before the parties even have to make an argument. And I believe there's something else. Have I addressed everything you were looking to have addressed?
No.
Well, the fact that the places that do have it called as rent control doesn't have to be expressly approved by the legislature. And don't they need a board that oversees it? Am I wrong on that?
Yeah, that's precisely, what rent control is. There would be a board established by the county that would, adjust rent based on the market. And that's not what this law requires. And basically, excuse me. So one of the grounds for an eviction under the proposed rule is non-payment, but there is language in there that, will filter out cases where the landlord has increased the rent for the purpose of getting around the good cause law. So there is, it simply puts the question of whether or not a rent increase, if one actually applies to a particular eviction, was imposed for the purpose of getting around the law. It does not prohibit, a negotiated rent increase between a landlord and tenant. It doesn't establish that sort of rent control board or anything like that. It's simply, language in our law that addresses the likelihood that in order to get around the good cause, grounds and not have to argue them, you could have an unscrupulous landlord who decides to increase the rent beyond what's justified by the market or several other factors that we've included in the law.
Okay,
No, I go, we'll let other folks talk.
I believe the next committee member with a question is Councilwoman Farrell.
Hi, so I have a few questions, and I should say, in my ward, I have, and I don't know what this is compared to other wards, but I happen to have a lot of landlords that are smaller landlords that happen to live in my ward and own additional properties in my ward. And so there's, and they actually agree with a lot of the different pieces of this, but they do have some valid concerns. And I think it's kind of because of COVID and the impacts on people, no evictions happening. I'm having some pretty dramatic tenant issues that are impacting the neighborhood. And so what I want to do is kind of the main issues. So I guess I want to bring up some of these different issues because I do want to either be able to explain them how this isn't an issue to some of the landlords that have reached out to me, or maybe say that should this be looked at in a different way. So one of the big issues that was brought up to me is the lease renewal. So, you know, it's a pretty common and I also, even as a former tenant, I also don't totally understand that. So you can only have a year lease because there's a lot of situations when I was a tenant, I did not want that. Like I, you know, would ask the landlord to do like month to month afterwards, or, and it's also something that for several of my landlords, one of them, they actually started getting into owning properties because they love historic properties. And their whole concept was to be the ones to rehab them and do it historically appropriate. And they are absolutely stunning. And they also care about the city. So it's a broader thing. But they also have a very strict no smoking policy in their units. And there are people that will violate that. And those are regularly tenants that they don't go through eviction proceedings, but they just don't renew their leases. You know, they kind of say, listen, you know, which is, I think is reasonable. But with this, it doesn't look like that's an option. And so would people have to actually go through an eviction process if it wasn't working out? And does that actually make sense?
Yeah, so there's nothing in the law that requires a year lease or anything like that. And the state of the law as it is now, you know, if you did have a tenant who, even at the expiration of their lease, refused to, you know, surrender the apartment, you would still have to go through an eviction in that case.
But is it an so, and they, you know, I agree. It looks like you just automatically, that the landlord doesn't have a choice on lease renewal.
Yeah, I mean, that is not in there. I mean, what is in there is that if, you know, in the situation you're describing where a landlord has and a tenant, the landlord-tenant relationship has come to like a natural conclusion. If the landlord wanted then to pursue eviction and the tenant refused to move out, the only change under this new law is that the landlord would then have to articulate in court that I'm pursuing eviction because this tenant is violating a substantial lease provision, in this case, smoking.
Okay, so in other words, let's say that this is happening and I'm living, Joe is renting me an apartment. Joe happens to be next to my head here. It's probably not for everybody. And Joe is like, okay, I don't know, as Mike said, I want to rent to my niece, whatever. So Joe's like, hey, Jenny, I'm not going to renew your lease. That's fine with this. So in other words, I can go back to my landlords and say, no, don't worry about it. You don't actually have to renew leases.
I mean, in that situation, I guess in that situation, if your landlord wanted to evict you because they wanted to have a family member move
But no, it's like the end of the lease. It's not an eviction. Right. So I would agree. Like an eviction is a different conversation. This right. is just the lease ends and now. And
absolutely,
we're not going to renew the lease.
Right. Yeah. And if you as a tenant accept that, then, you know, just as you can now.
I guess that's the thing. Like how. Right. So I have to accept that they're not renewing the lease. And if so there is the lease renewal, the only way for a landlord to get out of a lease that they don't want to be in is in eviction proceedings. Once they enter into
Well, what usually happens, I'm sorry, I'm jumping in because I'm a former housing court attorney. So I've seen this many times. So what usually happens when the natural end of the lease comes to an end, now under the Tenant Safe Harbor Act, you have to give them a certain notice beforehand. And if they stay past that time, you now have grounds for what is in a form of an eviction proceeding. It's called a holdover proceeding now, which is separate from like a non-payment proceeding. So with this provision, with this law, it doesn't really affect that one because it's now a substantial break from the lease. Because now when you're on a holdover proceeding, the courts understand this, that you are no longer under a lease. You are now staying beyond the past terms of the original lease.
Okay. So there's still a process where, you know, if, again, and clearly I have severe asthma, so I'm not giantly smoking in Joe's pretend apartment. So there's still a process where a lease does not have to be renewed.
Yes.
Correct.
Yeah, I mean, in 90% or 95%, probably even more of landlord-tenant relationships, move-ins, move-outs are all negotiated. And this law doesn't have anything to say about that.
Okay,
Yeah.
Fantastic. And that's why I wanted to clarify these different pieces, because I don't totally get why that would even be a rule, because that doesn't seem to advocate for the tenants.
Yeah, that wouldn't benefit anyone. Yeah.
You know, so then there's the other piece of the rent increase issue. And this comes up with so for the example of one of my constituents who buys properties that are not in the best of shape and then beautifully and lovingly rehabs them. There a lot of times, if they're doing, because they have another job, like this is like a labor of love on their part, it is a dramatically different apartment, and it is also a substantial output of cost. So there's a totally, and they might rent it out. Maybe they'll rent out one unit while they're rehabbing the other, and it might dramatically go up in price because it's not even a comparable apartment. So what, and I think that's valid. I think if you are, and is there a function for that? Because my concern with that is that why would any landlord invest in their property then, especially old buildings? Because old buildings, rehabbing them, I mean, Rick could probably tell more stories about this than anyone else. It's not cheap. So I mean, my concern with that is I love when people do invest and people do put things in. I certainly don't want it to be, I think it's absolutely horrible to be used as a predatory thing. And I absolutely want that to be part of it. But I also think there's a valid point to, if you substantially, you know, if you put in $80,000 into a property, it's crazy to me that you'd be, I mean, if you think of it in terms of selling a house, like if you buy a house and you put a whole bunch of money in, you expect to sell it for a substantially higher price, or else why would you can't just do things at some point. You know, I would love it if people did that out of kindness, and please send everybody to Albany that wants to do that. But most people can't afford to do that. So what about that?
Yeah, Councilmember Farrell. So, I'm so sorry. Okay. So I was just going to respond to that and say that within the good cause section of, I believe we titled it Local Law F, but that's the good cause. You'll see that there are considerations that judges can take while the proceeding is occurring. So for example, if, I'm sorry, were you gonna?
Yeah, but that doesn't have anything to do, so that's during eviction. I'm talking about, this is just, I have a property and I want to put in $30,000 in updating the property. And then I want to, like, if I do that, and it's still rented for X amount, I can't recoup that cost. So then I'm like, I'm not going to do that.
So there's nothing in this law that would prevent a home or a property owner from increasing the rent to accommodate for costs that have been put into the property to improve the property.
The only thing that state law has is that if they currently have a tenant and they're already on a lease and that they want to raise the rent and it's a certain threshold, which is 5%, they have to, under state law, give notice if it's a 1-year lease or less. I'm sorry, it's the numbers mess me up, but 1-year lease or more, they have to give a 60-day notice of, we are raising your rent by more than 5%.
Which is totally, I mean,
And
that I have
That's
no
all that's really
issue.
on the books right now.
Right. So there's within this is this rental increase, you can actually increase rent if, you know, if I suddenly turn my studio apartment and blow out, who knows, like I put it on addition and it's now like a palatial mansion. I'm able to then substantially, maybe even triple the rent with that because I put in, that's not stopped.
No.
Okay. Thank you. That's really helpful because I think that was a really valid point that I could, and the other thing is, you know, I read through the pages of legislation, but we also have landlords who are not necessarily, they don't deal with this. So it's helpful for me to be able to talk to them and say, no, you still can. And then this is a piece that, this is a unique situation that I'm dealing with that actually Rick is aware of, where it just so happens that I have a tenant issue where, and the landlord is like, again, small time landlord, scrimped and saved to have, I only think she has a couple of properties. And the tenant hasn't been paying rent for a year because of COVID and other things. But the tenant is actually purposefully destroying the property I think there's other issues involved that are not, you know, we're trying to get support on, but it is one of these issues where this landlord is trying to do everything that they possibly can to support this person, but they're also, there's restraining orders through the neighborhood. This is a dramatic situation, but how is it, so in terms of the expansion powers making repairs for, what if it is something like, I mean, is there any sort of provision, like Rick, do you have flexibility? Because I also, like, this is a situation, if I sent you the address, Rick, you would know exactly what I was talking about. You might even know now. And it's actually, so it's a difficult situation because the she doesn't have, I mean, hasn't been able to pay her mortgage. And she's really upset about the state of her property, keeps trying to replace windows. They keep purposefully breaking them. And so, you know, what about a situation like that? Is there some sort of safeguard when it isn't the landlord that's the bad actor? Because let's be real, there's all sorts of people in this great wide world and not every situation is cut and dry.
Yes. So off the rip, that I get the final decision on whether or not we're going to enact that power or not for that particular circumstance. And it's primarily, just so you know, it's primarily for when the landowner has, you know, purposefully not responded to take care of the issue. So if we're standing there at 2 a.m. and, you know, the issue is not tenant caused, and we cannot get the respondent, you know, we can't get the owner on the phone, or they tell us they're not going to take care of it, you know, we'll have the ability at that point to choose, do we wait till morning and see if we can work it out? You know, so no, it's not.
To say, I absolutely love this based on the other side. So I'm really pleased with this. I just know that there are, and this people are people, and it's not a simple situation. So I just wanted to, those were the different concerns that I've heard, and I will definitely, I appreciate this input, and JR, I'll probably circle back with you at some point because I'd like to be able to respond to my different constituents that I've talked to about it, and kind of put their minds at ease about some of these issues. So, and thank you to the sponsors for putting this together, because I absolutely believe in this and appreciate all the work that's gone into it.
Mr. Chair, I'm sorry if I may, I don't think we announced all of the members who are not on the committee that are also present. So I have Anani, Fahey, Dochette, and Ballerin as non-committee members that are also present at tonight's meeting. Did I miss anyone?
I don't think so, from what I can see.
Yeah, Tom Howie.
Where are you? Yeah, I can't see him.
All right,
Hello?
Tom Hoey also for the record.
Thank you.
And then I believe you have a question from Councilwoman Frederick, who's a committee member, and then there's several non-committee members that have also indicated that they have questions.
Kathy Fahey's, oh, she has one. Well, the Wusu's a committee member, I believe.
Yes, he is. I'm sorry.
So we'll take the committee members and then we'll go with the sponsors after that, if that's okay.
Lucy, you can go first. You got your hand up.
Oh. Yeah, I think Councilmember Farrow asked most of the questions that I've been hearing from most of the landlords in the neighborhood. But I do want to say that I stand by the package, a list of legislation that's being put forward, particularly the one that I'm sponsoring, which is the unsafe, unfit. Quite frankly, we're simply asking property owners to do the right thing, right? To do the repairs and maintain their properties, to help us with the blight that we are seeing in our city. And also, I know very too often people think that council members are legislating against landlords. This piece of legislation is going to help landlords. Sometimes landlords cannot, or property owners cannot afford to make the repairs, and to have the city come in and make the repairs so you can pay it in the back end if you choose to. That is going to help property owners, and it's going to help tenants. During this pandemic, there was a landlord wanted to get their tenants out. There was a issue as it relates to the electric problems. The tenants were evicted because the place was unsafe. They stayed at a hotel for a couple of weeks, and after staying in the hotel, not being able to afford the hotel moving forward, they became homeless. I had to make several phone calls to find them a place, and ultimately I was able to assist them. So I look at this piece of legislation, particularly Local Law H, as it relates to the city helping property owners when they're unable to fix structural and emergency problems. My question more so is the liability aspect of it. And Rick, you probably have the answer to this. Can you give us an example of some of the things that the city will come into your house and fix? Very too often I was hearing, speaking to one of a property owner the other day, and was saying that the liability aspect, if the city comes and fix it, and then something, let's say a gas tank blows up, who is liable? Is it the property owner or is it the city? So if you could speak to that, that'd be great. Or Rob McGee, whoever.
Yeah, I'll let the attorney speak to the legal end of things.
Right. Yeah, so we've gone through a vetting process in terms of selecting the contractors, and they'll have to be fully insured and qualified. So we're making sure that any contractor that's called upon to do any emergency work is fully qualified to do that work. We will oversee it, and we'll have again, they'll be fully insured as we will be. Whether or not we're liable, it's going to depend on the facts of the case. It's hard to say one way or the other, but significant and substantial safeguards are going to be in place to make sure that the people who do the work are qualified and know what they're doing.
Thank you.
You're welcome.
Again, we're trying to look at this. The piece of legislation that we're putting forward is to address urban blight, a disease that's plaguing many cities all across the state of New York. And I want to, and the mayor mentioned it. I want to thank the Attorney General for the $1 million RISE grant. It's definitely going to put a dent in the blight that we're seeing. And just to speak on another issue as it relates to the good cause, it's inconvenient to come to the courts and to give an explanation for everything. I understand that aspect, but I want the landlord and property owners to understand this. If you want to increase the rent, if you justify it, the judges will work with you. The city will work with you. If you want to bring a family member to come and move into the house, you just have to justify it. That is all in the legislation. So just don't want to look at it as we're just going after property owners. This also protect property owners and also protect tenants. If there's some criminal activity that is happening inside of your property, as a council member, I will help you evict that person, you know? So just understand that there's a list of things that that the city of Albany, you don't have to, all you have to do just justify to get the tenant out. So again, we want to work with property owners, work with residents. We're all in this together. So I just want to thank the staff and also all the members that worked on these sets of legislation. Thank you.
I believe Councilwoman Frederick was next with a question.
Thank you. So I have a question in regards to local law F, grounds for removal, subsection 10. I want to understand, is this stating that the landlord needs to give 5 months notice to not renew such lease? And if so, well, in the example of a current lease agreement where the tenant has X many days to let them know they're not going to renew. And if they don't renew such lease and they don't give notice that they're leaving either, they could become like a month-to-month tenant in which the landlord has the ability to then, end the lease on that monthly basis. Does that now conflict in that example? Will that now conflict with the new subsection 10 and require a 5-month, like a 5-month period?
I'm sorry about that. I was just reviewing it. And I think, is it subsection J, Councilmember Frederick? I just want to make sure I'm reading correctly.
I believe she's reading section 328, number 10, subsection A.
Okay.
328, number 10. Yep.
Okay. Yeah, so the way that one had come about was it's in with the consideration to the landlord who has actually wanted or tried to get under a new arm's length tenancy or lease agreement with someone else. So if I'm reading that one correctly, I just want to make sure I have the correct version in front of me. But that was to give the tenant 5 months notice that the non-renewal would occur, essentially saying that, hey, I have someone else coming in, and they have to provide proof that the landlord does have a new tenant coming in. Rob, I don't know if that answers the question, but that's sort of the framework behind that subsection.
Right. Yeah, that provides, I mean, yeah, Laura described it pretty well. It does provide what is essentially a no-cause eviction where there's been a genuine agreement with the landlord and tenant over an extended period of time. And it's kind of engineered around the idea of a student who knows they're going to be graduating and moving out of the city. And they make that promise to their landlord. And then based on that promise, the landlord then enters into a lease agreement with the new tenant. In those cases, that will provide what is essentially, I mean, that itself provides good cause for an eviction in that case, if the tenant who's promising to vacate then backs out on their voluntary agreement.
Okay, so sorry for the background. If I'm understanding correctly, then this is more so on the tenant side, or is it that the landlord must give 5 months notice? Because I'm just wondering how that works,
Right.
like in a month-to-month lease.
Yeah, I mean, when the landlord pursues the eviction, if it gets to that point, what the law is saying is that the landlord needs to present one of the grounds here. And subsection 10 is basically one of the options the landlord has to justify the eviction. But if it's the case that the tenant is not paying rent or is violating their lease, I mean, those are still available to the landlord to justify an eviction in that case.
Okay. So more in conjunction with something else, essentially.
Yeah. I mean, it is, again, it's for those unique situation where the tenant and the landlord have a long-standing agreement that the landlord has relied upon. And that will support an eviction warrant.
Okay. Thank you.
Can I raise my hand?
Joe,
Can I raise my hand as the last committee member?
oh,
Tell me if I was right or wrong. I was a landlord for probably 25 years, a nice 2-family. And you know, I put in all new windows and everything, okay? And I probably waited, according to this, if I waited 2 years, okay, to raise the rent, that wouldn't justify it? Would I have to have told them 5 months before? I mean, I put in, I had good tenants. I had good tenants, I didn't want to lose them. But at the same time, I wanted to fix the place up and make it, you know, make it so down the road, when I went to pay for college tuitions, I could make some money off the house. But I guess what I'm getting at, you have to tell somebody like that, I'm raising your rent, and because I'm putting new windows in, I have to do it ahead of time.
The only time that would come into play is, again, if you were pursuing an eviction against that tenant. I mean, there's nothing in here that prevents the tenant from
Yes, sir.
agreeing to a rent increase.
That
But
just
even if
comes
you
down
were,
to
you know,
when
you
you're
found
in
your,
court.
oh, I'm sorry,
No, that just comes down then to when you're in court.
precisely.
On the other hand, I had one guy, he was a slob for years, okay? And he liked it the way it was, and I wasn't prepared to put the money in that one. I'd fix the other one up and I let him go. And then
Mhm.
when he, you know, finally decided to go, it was a lot of work, but the rent went up pretty good, you know?
Right.
You gotta try to
Yeah, and the
be
law
fair.
preserves that flexibility, you know, with an understanding of that's how those situations go. And like I said, it's only in those worst case scenarios where you find yourself, where you aren't able to negotiate an
And that's
exit.
why some people are getting scared that this was a rent control. okay?
Yeah,
And
it's not that.
That's,
No.
that's how people are looking at it. You're
Mhm.
doing, you know what I mean? Just think you're gonna raise the rent, you can't do it more than 3% a year. And that's the feeling that's going around the city, I believe. Other people have heard that.
Mhm.
I'd just like to discount that one. Thank you.
Right, thank you.
All right, Mr. Chair, now you're ready to move on to comments by non-committee members. And I believe Councilwoman Doshette had her hand up for a while. So I don't know if you want to start with her and then move down the list.
Are you okay with me going, Joe? All right, thank you. So I'm reading this. I'm looking, I want to deal with one law at a time personally. I'm looking at local law F. And I'm reading this differently than what I'm hearing the answers to Ms. Farrell's questions be. It says no landlord shall, by action to evict or recover possession by exclusion from premises, failure to renew any lease, or otherwise remove any tenant from housing accommodation except for good cause. I read that as you can't just simply decide not to renew a lease in order and then bring a proceeding because you've refused to renew the lease. Or, and ditto for the month-to-month tenancy. You can't just decide, okay, the month-to-month tenancy is not working for me. I'm going to provide the person with notice that I'm moving, you know, I'm going to be listing the premises. So I just want to make sure we're all on the same page about this. Am I right that essentially this prohibits you from not renewing if the tenant wants to renew?
Right. Yeah, I mean, I don't want to get hyper technical here, but it doesn't require a renewal. It just makes simple non-renewal, you know, it removes that as a ground for an eviction. And JR put it pretty well before. You really have two ways to get an eviction warrant in New York State. One is for non-payment of rent, and one is for a simple non-renewal of the lease. And what this law does, in its essence, is for those cases where you have a simple non-renewal, it requires the landlord to present good cause for why that is a justification for evicting the tenant.
So, but this says the landlord can't do that. So,
well, yeah, I mean, the landlord does, because the landlord still has that, like, you know, like I said before, you can still negotiate with the tenant. You can make whatever arrangements, that are voluntarily entered into. You can still make those agreements. But if there is that disagreement and the tenant, and there, again, in those worst case scenarios, when the landlord and tenant find themselves in eviction court, the landlord is still entitled to an eviction warrant so long as they prove that they have good cause for the eviction. And the good cause that we have in the law, it's all the things that, are discussed in court, in housing court anyway. Things like not paying your rent, not following the lease, using the property illegally, all those sort of common sense things. This is just a formal requirement that those be articulated in court, as opposed to simply saying, I'm, deciding to not renew the lease.
Okay, I'm sorry, I thought I heard you or somebody tell Ms. Farrell something different. I thought that the landlord could just decide not to renew because they have decided that there's, it's not working for them, essentially. All right, so there needs to be good cause. And then with regard to the thing that Ms. Frederick was just asking about, I do find this confusing. I do find it, having been a landlord once, I do find it a little disconcerting that twofold. One is, it looks like you can only discontinue a tenancy that is based upon a lease if you give the tenant, unless there's mutual agreement, but you have to give the tenant 5 months notice. And the tenant essentially has the ability to consent to that, but then the tenant can withdraw anytime up to the point the landlord enters into a new lease, which strikes me as being a little challenging because you need to know when the place is going to be vacant. And then you go out and find another tenant. This is not necessarily helpful to other tenants who are looking at apartments, I think. Because you don't know if that rental is really going to be available. Because the tenant, you can go and look at that apartment and say, oh, okay, I want to rent it. And then the tenant says, in the meantime, the tenant has said, no, I want to stay. And then that tenant has an absolute right to stay, according to this, if they sign a new lease. Is that correct?
No, actually, I mean, the way it's written is it's actually supposed to prevent that situation. I mean, once the new tenant has entered into an agreement with the landlord where that promise has been made by the tenant, the landlord is going to be entitled to an eviction warrant at that point. But otherwise, it leaves, I mean, if we're going to protect tenants who are renting units, it kind of leaves those particular tenants in the same situation that they are in now, wherein, a tenant can decide at the end of their lease period to say, I'm just going to stay, I'm going to refuse to move out, in which case, their landlord would have to go through the eviction proceeding anyway. I mean, that uncertainty is sort of built into the economics of the landlord-tenant relationship as it is. And like I said, we do try to provide some protection for that because, where the landlord has acted on a promise, acted in good faith on a promise like that, we want to protect the landlord. But yeah, I mean, like, under that scenario and under things as they are now, you can't protect a situation. You can't, guarantee a tenant's not going to say, I'm backing out of my promise to move out on a particular date. Now you have to go get an eviction warrant. It's not ideal, but it is sort of the nature of the relationship.
I think that this particular provision needs some work, both in terms of clarity and also in terms of, I think that it shouldn't be up until the point in the time the landlord has entered into a new lease. If a tenant has been provided with 5 months notice, essentially, and for them to, and then the landlord is starting to market it, you're taking up everybody's time where a particular premise might be being marketed. People are looking at it and then the tenant goes, oh, I've changed my mind. And I'm just entitled now to stay over, keep on paying rent, you know, so it's not a holdover situation, but keep on staying over. I just, wait for other members to chime in about that, but it seems to me as though it should be at least 30 days before the end, that they can no longer have that right to object to a subsequent rental of the property. I am also wondering about the impact of this on the courts and the timing. How long, when somebody goes to court to do an eviction now, how long does it take for there to be an actual eviction? Does anybody know? You might.
Like 3 months plus.
So it's 3 months now, and it may be even longer since you have essentially, you can't put somebody on notice, just, with a 30-day notice. In general, I favor this as a concept. I'm just thinking in terms of the practicalities of implementation and what we may not be thinking about. Filing fee is how much? Does anybody know?
$45 in the city of Albany.
And JR, could you explain, so 2 other things about this that I'm not, 3 other things about this, and JR, I just said you, but it really can be anybody. But one of my questions is, how does this, where are we saying that this does not apply in a holdover proceeding? I think we need to be clear in the legislation about if it's a holdover situation, that we're relying on the state law, and this no longer applies if somebody has stopped paying rent. It almost seems like this is a little bit in conflict with that. I'm also looking for where it expressly says that, and I think that this should be in there, that the parties can agree by mutual consent, and what is involved in that mutual consent to terminate a tenancy. I think that landlords potentially, if there's a mutual consent, landlords potentially run a risk if they don't have actual consent, have an actual agreement. Right now, they provide notice on a 30-day, month-to-month tenancy. They provide the notice. That's all the proof they need. Now, for us to say it's got to be by that the tenant can stay over and the landlord can't evict, where's the provisions that say by mutual consent, essentially, that and what kind of proof is needed in a court for to show, oh, these provisions don't apply because we had mutual consent to the end of the tenancy, and the landlord has, re-rented, et cetera. For a month to month, that's a little different than the lease kind of situation. And the final thing is, I don't see, I would love for somebody to point out to the provisions that would it looks to me like there's this rebuttable presumption, even if you've done improvements, that if you increase it by more than 5%, you potentially need to, you potentially could not withstand, not prevail in a court proceeding if you've done substantial improvements to a property, because it creates a rebuttable presumption that if you have 5%, if you've increased by more than 5%, that is essentially a constructive eviction in violation of this, or in violation of the intent. How do we arrive at a determination? How are we going to be instructing the court, and what is our intent with regard to how much a landlord could recover? Ms. Farrell suggested 300% increase in rent if there had been substantial renovations. Well, that might be appropriate if there was $30,000 renovations and the prior rent was $500 or something, but and so you're recovering the money over 3 years. But if you so I'm just wondering if we can provide some clarity on that particular issue in this legislation, so that it's just not automatic just because you say, oh, I have, $5,000 worth of renovations here, so therefore I could increase it by, 50% per month kind of thing, which may not be what our intent is. I think it's very ambiguous, the way it's written, vague. So those are my concerns. I'm hoping that we'll be working on tightening up some language on some of these issues. Thank you.
Joe?
Yes, I'd like
I
to,
think I'm next.
yes.
I have some concerns about how we're proceeding here. We have 4 local laws, and it was great to get an overview. We have a lot of members of the public here who are going to talk on, different laws. And I think each of the local laws, should deserve to be focused on. And we've already kind of jumped into good cause and good the first local law. So I was going to suggest.
This first meeting, Kath, it was meant to be just an introduction, starting with the mayor and then everybody, I wanted to get the employees that have worked all day, get them to, give their overview, and then a few questions, not so much the point that we got into them, but.
So I think it's going to be very helpful to hear from the public, and then we can begin to get into the individual.
We still have 2
laws.
sponsors, you and Alfredo, if you'd like to say anything, just generally about your introduction.
Well, I was, I'm the sponsor for Local Law I, and that has to do with some substantial changes to the ROP program. And I was really pleased to be the sponsor because, over the course of many years as a council member, it's been, I've seen so many properties that are in disrepair. A lot of times it's from the outside that I see it. And I can only imagine, the problems inside as well. And, there's been so many instances too, when we've gotten complaints about a property. And then when you try to go and track down a landlord, there are just so many hurdles to get some landlords. Of course, we have landlords who do, keep things up to code. But we're talking about the bad actors. And it's been incredibly frustrating at different times. Joe, I'm hearing you. I don't know. Oh, can people hear me? No?
No, I can
We
hear
hear
you.
both of you.
Okay. So anyway, some of the changes that are being proposed in local law I are going to help with tracking down landlords who tend to be evasive. You know, they're going to require a copy of the driver's license, social security number. If it's a corporation or an LLC, it'll require the EIN number, 2 emergency contacts. The idea of posting the ROP at the house so that when people are looking at a property to rent, they'll be able to see that this is a property that is registered. I think that's very important. You know, some of the changes that are being proposed for the fees, they'll encourage a more timely renewal, and I do support that. The change from 30-month to 24-month. Again, it'll enable the department to, the city to stay more on top of these rental properties. The ability for our chief building officer official to revoke an ROP, you know, if there are extreme code violations. I think that's makes sense as well. But I am very interested in hearing from the public. You know, there may be aspects of local law I that we need to tweak and need to look at more closely. So I'm looking forward to the discussion. And that's it. Thanks, Joe.
Now, Alfredo, you have the big piece, okay? And it's gotten a lot of discussion already. And this will need, I think, a lot more discussion, but if you have some things that you want to focus on right now, let it rip.
Okay, thank you, Joe. I just want to make some clarifications. I know there's a lot of fear out there from landlords, especially because it's been a very difficult year for landlords, and I get that. And it's been a difficult year for a lot of people. So, and I know that landlords feels like they got the short end of the stick, because you have to have your tenant go in there and ask for some of the assistance, you know, for you to get your rent. So I get that. But this is very different from what the current situation with the eviction moratorium. This is about addressing issues with landlords who do not take care of their property, with landlords who see their tenants as second-class citizens, who don't address issues and concerns that they brought up to their landlords. The 5% piece, that is there specifically to make it so a landlord does not refuse to renew somebody's lease just because they called codes on them because they haven't addressed issues with the property. It's not rent control. It's to tell a landlord, you cannot price out a tenant because they have called you to do your job. It is not so that landlords don't get their investment back from what they put into the project. It is so that landlords cannot intimidate tenants by telling them, we're going to raise your rent, you know, $300-400, even though we've done no work on your property because you called code on us. So that's the point of, you know, having that 5% on there. It is not rent control. If you buy a property, you fix it up, and you run it, and there's nobody in there, and the old rent was $500, and you put in brand new kitchen, brand new everything. Now, for you to do that, there's nobody in there. Okay, you want to rent that out for whatever you want, you can do that. This does not stop that. This stops it from landlords that have no work to their property, try to outprice tenants that have called them for not doing their job. So I want to make sure that's very, very clear. Now, if you read the document, there were clear, very, very clear and open ways for you to be able to evict a bad tenant. If tenant doesn't pay the rent, number one, that's a good cause eviction. If a tenant's not following your rules in your lease, So if you say no smoking, if you say there shouldn't be music being played, loudly, then that's a good cause eviction. Now you have to document it, which means landlords that allow their tenants to play their music, like landlords that I deal with, who let their tenants play the music till 2, 3 in the morning, and the tenants on the other units are calling and complaining, but they don't want to deal with it. Now those landlords are going to deal with it, and they're going to have an incentive to deal with it, so that they will address and change the behavior. And that's what this is about. If you're doing everything right, read the legislation, read it, and you will feel a lot more comfortable with it. If you are not following the rules and are not treating your tenants and your property and our neighborhoods with any respect, then yeah, you're gonna have to do more work. And our neighborhoods deserve that. Our residents deserve that. And I'm open to making any clarification that people want to make about the mutual consent. Because if there's mutual consent, that means the tenant and the landlord have agreed on something. And that's fine. If a tenant and a landlord agrees with something, you don't have to go to court. It's not about having to go to court for things that the landlords and tenants agree with. This is about what actually has to go to court. You can't kick somebody out because they call codes. You can't raise somebody's rent 300% because they called codes and you did nothing to their property. That's what this is about. This is about creating a fair environment. And for those landlords who do everything right and live and have properties on blocks that landlords don't do everything right, you're going to see improvement. You're going to see your property value go up. You're going to see the cause of complaints from your tenants that are calling you because someone next door is playing music go down. So I ask people, read the legislation, read it, because it is fair. It is worthy. And I appreciate the lawyers being here. I really do. I appreciate Rob. I appreciate having that legal expertise here because, they're the ones that break it down. But if you read it and you get what these numbers are for, then you get a much better picture of what this very, very reasonable legislation is about. And I do look forward to listening to the public on this issue.
Okay, we're about to do that, Alfredo. Michael O'Brien, can you hold your?
Well, mine was very quick. One point of
Okay,
clarification to what Alfredo said is the existing state law does have strong law regarding retaliation by landlords for complaints about codes specifically, and it has been enforced in the city of Albany.
Okay,
successfully.
Thank you, Michael. Danielle?
Mr. Chair, would it be helpful if when the person states their name and address for the record, they also talk about which piece of legislation the comment is for?
That will be great. And we are going, because of the number of speakers, we're going to limit this to 3 minutes apiece at this point, okay?
The first person that I have is Emma Smith. Please forgive me if I'm saying your name incorrectly.
I'll go over here because it's quite loud, my husband. I have several questions, more so, I had my comment
Well,
is
let me
kind
just-
of,
Let's make it clear. This is just comment. This isn't a give and take, okay? It's just comments tonight.
oh, so the code enforcement, other people won't be able to answer the questions because she said question will be at the end.
Will be no questions answered tonight. This is just a comment.
This is just public comment. You provide a comment and there's no question and answer during this period.
All right, well, I guess my main comment is, unlike barber shops and restaurants and retail stores, even daycares and other programs, housing providers and storage units have got absolutely nothing from the PPE loans, received absolutely nothing. In fact, the OTDA website is still defunct, it's not running. PPE loans are for every other business, but not for storage units or landlords. You lost money for almost a year because tenants you know, a lot of tenants, you know, decent slumlords will not be calling or even participating. They just get their money and leave. And they probably only come back to collect more money, and they can let their building go into the ground because they really could care less. And they probably have enough money to not care. The people who are in these communities, who live in the communities, who are trying to take care of the properties are the ones getting screwed over. I know they mentioned something about with the code enforcement coming to fix and repair so the tenants don't get screwed over, but they never did answer if they're gonna offer repair forgiveness, because obviously if the landlord can't afford to fix something, especially the tenant screwing it up, like someone said, the tenant's purposely breaking windows, the courts have been closed, you couldn't even file for eviction paperwork. So what are you gonna do, just have busted windows and then let the water ruin your own property that the tenants don't care about because they're about to leave whenever this free ride is over? A lot of tenants are just riding out the free eviction because why would they leave? They don't have to. And you know, if the tenants are destroying your property, unfortunately, and the landlords are stuck there and they can't, you know, your property's getting ruined more. You can't really evict them. The courts are now just opening up, and it's been like several months just to evict tenants. And I'm sure there's a backlog for that. And that's if the tenants are
A minute remaining.
a minute remain. And so I think it's interesting when they mention about helping the derelict property. Seem like a lot of decent property owners, from what I hear, are selling and walking away, or just walking away from the properties. And then you gonna have more and more defunct abandoned buildings. I don't see how that's helping anyone, because no landlord who can't is going to stay and go broke with tenants from hell. And no tenant wants to live in a building with other house, you know, neighbors from hell. They'll move out. I know several tenants moved out, friends of mine, because they had horrible, you know, neighbors. The landlords couldn't evict. So this is a lose-lose situation, especially with the no bail law and these horrible laws now. It's just going to ruin a lot of decent homeowners and tenants. So that's all.
The next person I have is Judd Feynman. Judd Feynman. Okay.
Maybe you mispronounced his name.
Let's see.
He's on. Hold on, I'll text him.
The next person is Todd Drake.
Yes, thank you. Good evening. I wanted to speak not in complete opposition necessarily to some of the ideas that have been brought forward here, but some of the comments that have been made beg a few questions, and I understand it's not a question and answer, but some of these things, like, you know, Jeopardy, kind of have to be asked in the form of a question. And, you know, I think the first question that comes to mind, and I hope the council will consider, is what is the basis for this particular law at this particular moment? I think the last speaker pointed out that property owners, and, you know, if I may, the term landlord is about 600 years out of date. Property owners have been laboring under a tremendous amount of regulation since 2019, but more specifically since early March of 2020. There's been absolutely no way to reclaim property for any reason, whether it be for non-payment or people who are driving the other residents out of the building with their behavior, whether it's illicit or otherwise. And it's very hard to reach the bar that is created in most legislation that allows for, if you will, the term bad actors. And I want to make this comment to the Common Council so that they're hearing from more than one side here. It is not so easy to deal with somebody, even if your law provides for it. And so the more restrictive it becomes in terms of terminating, or I guess the better word is not renewing a lease or a tenancy, the more restrictive that becomes, the harder it is for neighborhoods to be stabilized from the other perspective. When you have people that are disturbing their neighbors, as the last speaker mentioned, they leave. And they often leave the neighborhood because they may or may not find something available nearby. And if the goal here is neighborhood stabilization,
1 minute remaining,
I think it's very important that we consider that everyone turns to the property owner for relief, but the property owner for the last 15 months have had their hands completely tied. And I don't understand the timing of this particular law now, given that circumstance. So my concern is with the 5-month notice provision. and the residents' ability to then later recant consent to a non-renewal. I think there's a lot of ambiguity there. And I think there have been a few attempts to explain it, but some of the questions may not have been 100% accurate in terms of the direction to getting to the bottom of that. So I'd like to hear more on that. And I want to make sure that the council members fully understand, because I certainly don't, how that's supposed to work. If in
10
fact,
seconds.
I'm sorry,
10 seconds.
if in fact, someone would like to non-renew a lease, how is it that they can bar you from doing so indefinitely? Thank you.
The next person is Deborah, and I apologize for your messing up your last name, Pustarare?
I was gonna just let you go for it. Pusatir, but thank you.
JR, can we get the names and addresses of everyone?
I'm sorry?
We'd like to get the names and addresses of everybody, of all the speakers we should have gotten from the first couple.
Sure. I actually think we entered that when we signed up to speak. So do you want it again right now or us to type it in the chat maybe?
If they could just say it, because there's some other people listening and they might want to know if, your neighbor or anything like that.
Okay, so I live in Clifton Park right now. I own property on Clinton Avenue and Elk Street in Albany. I've owned down there for 24 years. And I just wanted to say that I appreciate that you folks are trying to clean up our city. I really, really do. However, I feel that a lot of these proposals that you're putting forward are stepping on the rights of us as property owners. With all due respect, in the 24 years I've been in Albany, I haven't seen any part of the proposed legislation that actually does have a solution to decreasing the blight in the neighborhood. I see it only as increasing penalties and fines and interest on property owners. That's not a solution. I know I've talked to Rick Pryor and other code enforcement.
Hello?
Sorry? Hello?
Someone else wasn't muted.
You may continue.
Oh, I apologize. Okay. I know that, I know that there's a lot of bad actors as far as property owners, but I think we also need to be honest that there's bad actors with a lot of the tenants. I own in challenged areas, and I pretty much babysit a lot. I mediate challenges, fights, bad behavior, guns, drugs, you name it. For you not to help me put boundaries around the tenants for damages to the buildings, the apartments, that doesn't change my neighborhood. I pick up garbage daily. I get fined for garbage all the time. Nobody helps the property owner, especially in challenged areas, make changes to the area. All they do is penalize owners by ROP fees and other fees that you're putting on, which I think is really out of control. You have 100% late fee with an ROP. How is that possible when your good cause proposal only allows a 5% increase in rent? How is that proportional? I find that to be a little bit out of control. I also feel, Kathy Sheehan had said on the onset of this meeting that the rationale for good cause is to deal with the housing crisis created by COVID-19. How can that be possible that there's a housing crisis when our courts have been closed for over a year and no one's getting evicted? That's just not a true statement, with all due respect. Good cause is government overreach, and it is, if you look at history, a bona fide forerunner for bona fide rent control.
30 seconds remaining.
I feel that good cause is only tenant-sided, and the property owner and their businesses are not considered here. This is our property. With that property comes ownership rights guaranteed by the Constitution, and good cause eviction is taking away those property rights. It's also taking and stepping into our business and our contract with our tenant, which is illegal. So I ask, with all due respect, government takes a step back, gets out of our business. Please let us run our property as we see fit, and to make the decisions we need to keep the quality of life in our neighborhoods where we think it needs to be. Please give us our rights back and stop taking. You're going to lose good landlords.
Time's up. Thank you. The next person is Asaf El-Kayam.
Hi, how are you?
Please state your name and address for the record, please.
Asaf El Kayam, 405 Hudson Avenue, Albany, New York.
You may
Let me
continue
know.
with your public comment.
All right, thank you very much. So first thing I want to say is when I sign a lease with somebody for a year or 2 years or however long I sign a lease with somebody, I agree as a landlord to provide good housing, have an ROP, and do what I need to do as a landlord. The tenant has requirements that he needs to do. At the end of that lease period, if I do not wish to renew his lease or her lease, then I have that right. I am not married to that person. I don't need to keep that individual in my property if I do not want him in that property. That's my basic right as a homeowner. You know, it doesn't make any sense that the city of Albany is going to tell me whether or not I should have a tenant that, for whatever reason, I do not want him or her in my apartment, that I have to keep him there as long as he keeps paying rent. It doesn't make any sense whatsoever. We all know 10% of the people cause 95% of the problems. You know, we can't get along with everybody. We can't please everybody, but we should not be limited past our obligation as a contractual agreement to keep housing somebody that we do not want in our property anymore. Whether it's, even if they're a good tenant, a bad tenant, on time paying, it doesn't matter. We should have the right to decide whether or not we want to continue our relationship with a person in our own property. That's number one. Number two, I agree with the city of Albany about the ROPs. Yes, the ROPs are a great thing. It protects landlords, it protects tenants. However, as I just stated, there's plenty of bad actors on both sides, on the landlord side and the tenant side.
30 seconds remaining.
Okay. All I'm saying is you should not infringe on our property ownership rights. Just like Debbie said, this is unconstitutional. And if we want to encourage investments in the city of Albany, you really need to reconsider these laws and the way they're written. They should not bind landlords' hands into having to rent to an individual that we do not want on our property. Thank you very much.
Thank you so much. The next person I have.
Marshall Miller.
JR, this is Judd. I was unable to connect before when you tried to connect with me.
We can circle back to you.
You hear me?
Yes, we can circle back to you. Thank you.
Okay.
So the next person is.
I'm
Marshall
sorry,
Miller.
I'm Marshall Miller. That's somebody else who's not muted.
No, we know. I heard you, Mr. Miller.
Oh, okay, great.
You may go though, Mr. Miller.
Okay, cool. Great. Well, thank you. So Marshall Miller, I live in the Mansion neighborhood, downtown Albany. I've lived here for 18 years. I prepared this impassioned speech, and then I was listening to the incredible, thoughtful comments of the common council members and realized that this is a thoughtful conversation. I'm just happy to participate in it on that level. I think listening to what people are saying is that it seems like there's a split in that perhaps there's the rule followers and then what we might call the chronic code violators. And I think so much of the efforts of the city, the code enforcement officials, the tenants advocacy organizations are sort of dealing with the chronic problems. And I think for those of us who are rule followers, some of the legislation that's sort of written in mind for the problems leaves us kind of wondering like, okay, how does this work? How does this make sense? And I think that may be a helpful way of sort of thinking through this. For me, this is particularly the case around local law I, and I really appreciate Ms. Fay saying that we could take a closer look at it, because I feel like it does need a closer look in terms of thinking through some aspects of it. One thing that concerns me in particular is the idea of having to hang the ROP with phone numbers on the wall. It would seem like this forces tenants in single family homes
to basically have this government document on their wall, which they should be able to decorate their homes how they like. And I think in multifamily units, it puts the landlord in the position of having their phone number and these emergency contacts who may have been roped in as family members. I know my 78-year-old mother has been an emergency contact of also having their phone numbers sort of publicly on display. I have a tremendous respect for the common council members who are, in the public eye and your phone numbers are listed, but not everybody is in a position to have that be public. I think there are other ways to do this. There's been concerns about the city having access to the numbers, but you'll already have that on file in case of an emergency, and making sure the tenants have the numbers, much in the same way there's lead disclosure in which you have an exchange so people can contact each other in case there's a concern. I think that, and I'm going to say personally, a lot of small time landlords are just like, of course tenants can access us. Like, I live on the same block as my tenants. I've told them they can ring my doorbell at 3 a.m. if there's a problem in an emergency. Like, we're all happy to do that, as opposed to people who are, aren't even absentee landlords who are in New York or out of state. Same issue around the timely renewal question, in that I understand codes is really busy. I have a lot of respect for everything on their plates. It does seem a little odd that this has no reminder letter. And it's also really confusing to me. You would increase the frequency and the expense of ROPs without dealing with the fact that the majority of rental units in the city don't have ROPs. And I think you need a way to remedy that, onboarding people, not penalizing people who aren't aware of the law. If you care about everybody having smoke detectors and carbon monoxide detectors, you need to deal with all the buildings that aren't registered, as opposed to increasing the frequency and the cost for those that are. So really appreciate you taking a look at these issues and sort of resolving them. I realize these are complex issues. I'm happy to talk about ideas and solutions, including streamlining the process for people who are already following the laws and registered, but that's an ongoing conversation to have.
Thank you, Mr. Miller. Time's up.
Thank you.
The next person is Anita Thayer.
Thank you. My name is Anita Thayer. I reside at 196 Mount Hope Drive in the city of Albany, 12202. I'm speaking tonight in support of local laws F, G, H, and I of 2021. First of all, I applaud the sponsors of this proposed legislation and all those who did all the behind the scenes work to pull these proposals together. These steps represent an out-of-the-box effort to address what some commentators referred to as urban blight. These local laws are a much overdue effort by the city to stabilize our neighborhoods. Too many of us have seen the impact of a poorly maintained rental property on a block, a street, and a neighborhood. Who hasn't driven down an Albany street after an absence of a couple years and wondered, oh my God, what is happening here? Together as a group, these 4 pieces of legislation are designed to bring housing stability to our tenants and therefore stability to our neighborhoods. And when we talk about housing stability, what we mean is the tenant's right to maintain a home. When landlords talk about their right to control property, everyone seems to forget that people actually live and make their homes in apartments and in rental property. And just because a landlord has a change of heart or has a whim does not mean you should lose your home. Together as a group, these 4 pieces of legislation are designed to bring housing stability to our tenants and therefore stabilize our neighborhoods. Proposed local law F, also called good cause eviction, gives tenants the right to continue to live in the rented home, even if they need to complain to the codes department or the health department or another agencies about certain conditions in their apartment. Tenants will no longer have to fear retaliation if they make a complaint about a repair not done, a heating system that is not working, or an electrical outlet that is sparking. Proposed local laws H and I address the critical problems that happen when a landlord refuses to make much needed repairs. These laws will give the building department, after giving advance notice to the landlord, the option of getting the repairs done themselves, rather than condemning the building and forcing tenants onto the street or into homeless shelters. It is clear that this is a better solution to the dilemma than what is provided by current laws. Proposed local law G will require the posting of ROPs together with contact information for the
30
landlord.
seconds, please.
This comprehensive legislative framework represents a holistic approach to the issues we face in our neighborhoods in Albany. Good landlords committed to maintaining their property, keeping their apartments in good repair, and taking pride in our neighborhood should have no objection to this legislation. In fact, these proposals enhance everyone's investment in our city. No one wants a rundown building as a neighbor, not a homeowner, not a tenant, and not a landlord. Thank you.
Thank you so much. The next person I have is Julie Henderson. I don't see.
Julie Henderson did not sign up to provide a public comment, but provided a statement that says, I support the City of Albany's housing proposals, local law FGHI of 2021. Please pass this very important legislation. And I believe we're supposed to be circling back to Judd as well.
Yep. Mr. Feynman?
I'm here.
Yep, you make, state your name and address for the record, please.
Sure. Judd Feynman, 744 Broadway, Albany. Danielle, thank you for allowing me to speak. That was very nice of you. Many parts of this bill or recommendations I totally disagree with. The fact that there were meetings in late fall in which there were supposed to be additional meetings that never occurred is really unthoughtful of the City of Albany. I'm going to start very quickly, and I'm going to start with the ROPs. I don't believe there's a landlord out there that disagrees with ROPs. The increased cost of the ROP from a 30-month to a 24-month is a 25% increase. Number two, the emergency repairs that are going to be allowed by the City of Albany by whoever the provider is that's approved by the City of Albany is a very questionable act upon the City of Albany because they couldn't reach that landlord or whatever. The circumstances are not necessarily clear as to what happened, how many times the landlord has tried to make attempts to do repairs, denied repairs, serve the tenants certified letters, written notices to come and do the repairs and continuously denied. And mind you, each time a landlord sends a maintenance person or hires a company to go there, they're charged back. Minimum rate right now for any certified or maintenance person runs roughly a minimum of $95 an hour to $150 an hour. So just think about that being denied over and over again. Okay, so far as rent control, Mike O'Brien happens to be 100% correct. The fiscal impacts, I love that term that is being presented on the bottom of the pages. Fiscal impact, none. I really don't believe people understand what fiscal impact is, and I would love for the Common Council to explain that to their fellow members as well as the public as to what a fiscal impact is. Next, eviction by lease provision is a perpetual tenancy. There is no landlord, and I've been doing this for over 40 years, and many of you Common Council members are as old as I am, if not older. Understand that there is not a landlord out there that says, I'm going to rent an apartment and evict the person. I'm going to rent the apartment and I'm going to cause damage to the apartment in order for the tenant to be unhappy, in order to want to call codes. Next is a boiler. A boiler calls approximately $5,000. $5,000 return at a $40 per month rent increase at an $800 per month rent will take 10 plus years, 125 months in order to recoup that cost. I hope you all understand that about a dollar breakdown for landlords. Thank you. Be well.
Thank you so much. The next person I have is Arlene Way.
Arlene Way did not sign up to speak in person, but provided a comment. I strongly urge the Common Council to take a balanced approach when protecting tenants from evictions. Just as there are predatory landlords who take advantage of tenants, there are predatory tenants who are taking unfair advantage of landlords who are trying to do the right thing. Please listen to landlords who are trying to do the right thing, but are being harmed by predatory tenants. They have a story to tell. I worry that unbalanced policy would lead to unintended consequences for the affordable housing market and for vulnerable populations. That was her comment. And I believe Gabriela Romero signed up to actually speak and is also with us.
Yep.
Everyone. Can you hear me?
Yes.
Great. Hi, so my name is Gabriela Romero. I live at 490 Madison Ave in the city, and I've lived here as a renter in this neighborhood directly around the Washington Park area for the past 5 years, first on State Street, then on South Lake, and now on Madison Ave. And I'm here tonight to support the housing proposals, local law F, G, H, and I urge this group to move them out of committee with a positive recommendation. And the most exciting piece for me as a youth and a renter for the entirety of my adult life are the changes to the ROP, the local law G, requiring the emergency contact information and tenants' resources to be posted visibly in the building. And this, combined with the passage of good cause evictions, local law F, is really huge. And I want to share a personal story with you, some problems that I've had as a renter in my old apartment on South Lake. Very, very, very cheap rent, but at times kind of concerning living conditions. At that time, I didn't have the time or the resources to really move myself somewhere else. And because I wanted to stay in the neighborhood and was paying the cheapest rent, I really didn't know what to do. I didn't have anyone to contact when the power was out or when hot water stopped working or when every 4 or 5 months, there was brown water coming out of the shower or sink faucet. And as a tenant, I was put in a really fearful and kind of powerless position. No one to directly contact to address these issues. And if I went higher to complain to the city, I was afraid I'd get evicted for complaining. And I loved that area. I was scared and I wanted to stay in the neighborhood, knowing that I had the cheapest rent. So I worked it out and I waited long periods of time to get these repairs. And it's kind of stressful as a law student and then a young public defender, not knowing what to do, and kind of embarrassing and a little upsetting. So I'm not the only one to feel this way. I know you guys have heard a lot of comments today, but I have friends and even extended friends in social circles that this type of thing that I'm explaining, brown water coming out of faucets or not having hot water or not having electricity for periods of time is normal. And there's a lot of people my age, renters, that feel this way, but we keep moving. So that's why this type of legislation is needed. And this package of bills really empowers people. It gives them the resources they need to advocate for themselves and prevent retaliatory eviction and retaliatory actions in general by landlords, allowing people to stay within their space, but be able to speak up about these problems.
30
And
seconds remaining.
I really wish I had this 3 or 4 years ago. I strongly urge the committee to pass local law F, G, H, and I out of committee with a positive recommendation. And for the common council members that are watching, I urge you to pass this when it gets to you for a vote. Thanks.
The next person I have is Danielle H. No last name, just the letter H.
Danielle H., which wishes the following comment be shared with the council. I support this. I'm currently in unsafe conditions, cannot find a new one because no one will rent to me on unemployment and disabled on SSI. I had one tell me I needed a 700 score, even though I've never been evicted. I sat 6 months with only tub running, no basins or refrigerator. Also, Caitlin Burns has signed up to provide this comment for the council to consider. I'm writing to you to express my support for the City of Albany's housing local law FGHI of 2020 as a HUD certified housing counselor working in a HUD certified home ownership agency. I find the need to protect tenants' rights vital. I'm hopeful that with the support of these bills, the New York State can continue to be a state that stands behind the need of securing safe and affordable homes for everyone. That was from Caitlin Burns, who provided a business address of 409 River Street in Troy, New York.
Next person I have is Gordon Mowbray. Mowbray.
Who would like the council to consider this comment? I am opposed to the proposed legislation because it is unfair to both landlords and tenants. It would increase the property owner's expenses and result in higher rents. Everyone loses.
I have the next person, Nick Bio.
Nick says, I support the City of Albany's housing proposals, local law FGH and I of 2020.
And then the next person I have is Jade Weiss. I don't see them here. The next person I have is Chase Coleman.
I'm sorry, Jade Weiss has sent this comment. My name is Jade Weiss and I recently moved to upstate New York. I have many friends in Albany and hope to see this positive change in Albany's up and coming housing proposals. I'm writing to you today to send support for the Albany housing proposals, which include local law FGH and I, stopping retaliatory evictions and improving housing should be a priority of the city and many others. Housing is a basic right, and if we must fight to have decent housing, the city should assist in repairs that landlords refuse to handle, and landlords should be held accountable. I've had several friends this year evicted in retaliation, and it was a nightmare. To stand your ground and ask firmly for a heater leak, or in one case, a mold problem to be fixed, and then be kicked out for requesting something inhumane. I hope that these laws help usher in more policy that protects tenants and continues to improve housing issues moving forward. That was from Jade Weiss.
And then I have Chase Coleman, or did I announce that one? No. Chase Coleman, let's see, don't see that. The next one I have is Joanne Busiogno.
So Joanne says that she is supporting the City of Albany's housing proposals, local law FGH and I of 2021. I'm a social work volunteer who has helped many refugee families with housing problems over the past 15 years. The conditions that many of these families live in are shameful, even though the rents are high. These tenants are often taken advantage of by unscrupulous landlords and rarely receive their deposits back when they move. I strongly urge you to pass these laws so that tenants can have adequate protection and can get the repairs they need without fear of retaliation, harassment, and eviction from the landlords. Additionally, I request that you consider legislation that would penalize those landlords who do not return security deposits when tenants move out and the apartment is in appropriate condition, often better and cleaner than it was when the tenant moved in. Please don't hesitate to contact me if examples are needed. And that was from Joanne Basagno. And then Chase Coleman just wrote to support the City of Albany's housing proposal, local law FGHI of 2021.
Okay, and then the next one I have is Thomas Vander. Nope, okay. The next one I have is Barbara Di Tommaso.
Barbara Di Tommaso just indicated, I support the City of Albany's housing proposals, local law FGHI of 2021. And I think we may have inadvertently missed Aiden Suchak, who says, I'm a lifelong resident of Albany South End, and I support the City of Albany's housing proposals, local law FGH and I of 2021.
And then I have next is Barbara, oh no, I'm sorry, Adrian Charles Hill. I believe they provided a written comment actually.
Adrian Charles Hill of 28 Delaware Terrace, 12209, provides the following. During the past decade, the incomes of the working poor in the Capital District have fallen or flatlined. Housing costs have soared and public policy has failed to bridge the gap. As a result, most of these families were devoting at least half of their income to covering housing costs, and eviction has not only become a common event in some of their lives, but an integral part of the business practices of many landlords in Albany. In the rental process, many times tenants are subjected to having to fill out an application, undergo a credit or reference checks, are scrutinized and judged because they receive entitlements, have Section 8 or a Shelter Plus Care voucher, and made to feel like a landlord is doing them a favor by renting to them. When truth be told, individuals and families are looking for stability in their lives, and it is never their intention to rent a place to live and then be displaced by eviction. As stated in Section 2, necessity for legislation, the New York State Housing Instability and Tenant Protection Acts, HSTPA, passed in 2019, provides protection for tenants that have the effect of delaying the initiation of any eviction proceedings. Excluded from the HSTPA is any requirement for the landlords or property owners to provide justification for said eviction or removal of tenants from housing accommodations in the city of Albany. This legislation seeks to bridge the gap. Before COVID, between 4,000 and 5,000 households were sued for eviction in Albany City Court alone every year. In Albany, 60% of households rent, totaling about 25,000 renter households. The number of lawsuits in Albany City Court represents somewhere around 1 in 5 renters being sued for eviction every year. Before COVID, half of those rental households were cost burdened by monthly housing costs. I cannot imagine what those numbers will look like moving forward and how they will continue to grow in the continuation and aftermath of COVID-19. How am I with time? Am I still within the 3 minutes?
You are.
In addition to the other trauma that people have faced during these unprecedented times, they will be hauled into eviction court faced with the possibility of being displaced, staying in a shelter, not having enough income to afford to move into a new apartment, trying to navigate a system that is not open to provide services to them, and the final consequence having it
30
be on
seconds.
their credit report following them for up to 7 years. I know from my work at United Tenants of Albany as an advocate, organizer, and working with staff directly in eviction hearings, that is overwhelmingly the same landlords who use eviction as an integral part of their business model. It is
Time.
all. Thank you. And that concludes the comment from Adrian Charles Hill.
The next one I have is from Julia Long.
Julia Long indicated that she would be present tonight to provide the comment. We
Yep.
also. if
The
she's
next
not
one we
here-
have, she's not here. The next one I have is Maria Rogers Makowitz.
Just Marie, oops,
I'm sorry, you muted yourself.
unmute. Okay. Am I good?
Yep.
Okay.
Please state your name and address for the record.
Maria Markovics. I live at 38 Myrtle Avenue in Albany, zip 12202. I'm speaking on behalf of Housing for All, and we really want to thank Alfredo and the other sponsors of these important housing bills. You know, the having rental property is a business, and you know, but the apartment is someone's home. And so, you know, good landlords have nothing to fear from this legislation. Responsible owners have been following much of what's being laid out in this legislation. So it's not, you know, it doesn't protect bad tenants. It protects good tenants, and that's really needed. This legislation, I think, by giving more security to tenants, really does enhance neighborhood stability. When a tenant knows that they cannot be evicted on the whim of a landlord, that the owner must have a reason for asking them to leave their apartment, they feel more vested in that housing and in the neighborhood. the apartment then becomes their home. For many residents now, it's not a home because they know that they can be asked to leave for no reason. Secondly, giving the building department the option to act to repair serious violations, we think will ultimately contribute to the demise of blight in the neighborhoods. And also it will save many, many families from entering into the shelter system. And the third thing on the ROP is that we support this legislation because it makes it clear and straightforward and open on the whole ROP process. Too many owners have ignored the ROP process in the past, and this legislation provides penalties. Hopefully the day will end soon when tenants
30
move
seconds
into
remaining.
apartment. Oh, sorry. Okay. 30 seconds. When tenants move into an apartment, and they'll know that there's been an inspection there. That does not take place now. So again, we support this. It's good for good tenants and it's good for good landlords, and it'll help regulate owners who are not responsible. So thank you.
Thank you so much.
Kristen Copper asks that the following be shared on her behalf. The City of Albany's housing proposals are an important step to providing safe and stable housing to residents in our community. As a local documentary filmmaker, I've worked with tenants to share their stories and experiences with housing in Albany. It's shocking to see the atrocious conditions many tenants are living in here. Cockroaches in the kitchen, broken windows and locks, buildings without fire alarms. The list of dangerous housing issues in our community goes on and on. If you'd like to see the conditions firsthand, please watch my video. I've interviewed tenants who report these dangerous housing situations to code enforcement, but instead of receiving repairs, they receive a retaliatory eviction notice. Tenants are afraid to assert their rights and to report problems in fear of this type of retaliation and harassment from their landlord. It's time for change. It's time for tenants to be able to safely assert their rights to a decent place to live without fear of eviction. It's time for the city to be able to step in and make repairs when a property owner neglects to do so. It's time to pass legislation to better the housing stock in Albany and improve our neighborhoods. It's time to pass local laws F, G, H, and I of 2021. A vote to pass this law is a vote to better our community. And that was from Kristen Copper. And I believe up next we have Susan Summers.
Hi, Susan Summers. I'm a third generation Albanian. I happen to live in Latham now, but we happen to own a property in Albany, and I've been a landlord. And lots of times I've had times where I've had to let people live there for free, and I've worked it out somehow. But that's not the point. I'm not here for myself. You know, I'm here to tell you that I'm also a realtor for 33 years and with the New York State Association of Realtors, and they have come out against this good cause eviction for several reasons. And nobody wants to see a tenant out on the street. Nobody wants to see a bad landlord abuse the system. However, what this is doing, it's misguided legislation. All it's going to do is hurt the small landlords, mom and pops that own these properties. You know, they buy a property. We have the highest taxes in the country, except for California. So we have all these extra expenses, and you're going to tell somebody that they can only make, that they've got a cap on how much they can make. You don't know what their expenses are. You don't know what they've got going on. As somebody else said, you know, if your furnace goes, that is at least $5,000. So it's got to be a better balance. Restricting landlords and punishing good landlords because of the bad people, there's got to be a better way. And this is not the way to do it. So thank you.
The next one I have is Dahlia Herring.
Dahlia Herring asks that the following be shared. And it's Dahlia Herring, 201 Park Avenue, Albany, New York. I strongly support the City of Albany housing proposals, local laws F, G, H, and I of 2020. In my work with refugees, immigrants, and other struggling community members in Albany, I have witnessed too many times when tenants feared to bring up legitimate complaints to their landlords because of the threat of eviction, did not notify codes enforcement about unsafe and unfit living conditions for fear of being displaced from their homes, and did not even know who to contact in case of a problem because ROPs were not posted often enough and or were not displayed in a prominent place in the building. These housing proposals are desperately needed to protect tenants from retaliatory evictions and to allow the City of Albany to make repairs on buildings when a landlord neglects to do so. Again, Dahlia Herring.
Next person is Errol Sweet.
Earl Sweet asked that the following be shared. My landlord cannot fix anything and won't, and he raised our rent $35. We have painted the whole inside of our house. We had a leak in our living room and we just bought new furniture. He said, just move the couch. I have multiple sclerosis and am on disability. He just don't care. What gives the landlords the rights to treat their tenants this way? I am confused.
The next person I have is Ann Korchak. Oh, she submitted the following. Albany is not only the state capital, it's also a college town. I'm a member of SPONY, Small Property Owners of New York, and a parent of college-age students that use off-campus housing. Today, I'm asking you to consider the implications of good cause eviction on local college housing community. The local schools do not have enough housing for all their students and have therefore ceded the housing of students to the local housing providers. This symbiotic relationship has been in place for decades and could be greatly disrupted by good cause eviction. Housing in college towns is much more cycle than in other markets. Students are staying in housing for 1 to 2 years and then moving out. Students are selecting their off-campus housing many months ahead of when they actually will move in, and landlords are expecting the current tenants will be leaving at the end of their lease terms in order to accommodate the next group of students. If a landlord is required to offer every tenant a lease renewal, this cycle will be disrupted. The availability of particular housing unit won't be known until just prior to the lease expiration, when many college students are back home and not in the area to select their housing. Housing as a college town cannot function like this. Students need to know that their lodging is settled for the next school year as early as possible. If they cannot secure off-campus housing, then they will insist that their school provide housing on campus, leaving fewer housing options for the incoming students. Word spreads quickly among prospective students when a school has a reputation for housing shortage. Can the local schools afford this disruption? The local colleges are a huge driver of the local economy and should consider the impact of good cause eviction that would have on college housing markets by not passing this legislation.
Next up, we have Karen Wentz.
Hi, can you hear me?
Yes, we can. Please state your name and address for the record.
Karen Wentz. I live at 6 McCulloch Ave in Ravenna, New York. I am an owner of a two-family in Ravenna, but I am also a guardian for my sister who is a tenant in Albany. So I understand both sides of this. I just want to say that some of the words that I'm hearing in the conversation tonight are concerning. Retaliatory is concerning. This is not an adversarial position. It is one of cooperation between a tenant and a property owner. I am opposed against local law F. I feel that it is overreach by Albany, the government, into private ownership of landlords. I think that we need to pause and just take a moment to think about what we're really doing. We don't want homeless people. We don't want people who don't have proper housing. We want to bridge the gap. This law will not bridge the gap. And that's about it. Thank you very much.
Thank you so much. The next person is Felton McLaughlin.
Hey, can you hear me?
Yes, we can. Please state your name
Great.
and address for the record.
Sure, Felton McLaughlin. I live at 180 Lenox Avenue, and I own rental properties in the city. And all the discussion around code enforcement, I think you're going to find every good operator landlord out there is okay with it. I certainly am. You know, I have issues with slumlords as any tenant would have issues with them, as you know, the city probably has issues with them. So cracking down on poorly maintained properties, that's a good thing. You know, the big concern here is local law F on the good cause eviction statute, because and I'd like to point out some confusion that seems to have taken place on this Zoom call regarding non-renewal of leases. You know, Jenny Farrell had asked Mr. McGee about, you know, do tenants have the right to not renew the lease? And Mr. McGee said, yes, they do have that right. Well, the way this thing reads, you know, they don't have that right. And I'm just going to read it for everyone. It's section 30-327, necessity for good cause. And it reads, no landlord shall by action to evict or to recover possession, by exclusion from possession, by failure to renew any lease, or otherwise remove any tenant from housing accommodation except for good cause as defined in section 328. Everything that's listed as a good cause are reasons that already exist in law, okay? You know, when a landlord chooses not to renew a lease, it's typically because the landlord wants to improve the apartment. You know, tenants can't go through the construction of new kitchens, new bathrooms. It's too disruptive. So, you know, when you tie the landlord's hands around choosing to not renew a lease, that is a big investment killer. And I would think that everyone on the Common Council who's listening to this, every one of you should want investors to be encouraged to invest in our city. That's the only way our housing stock is going to improve. Yeah, and the example I always give is Center Square, beautiful neighborhood. People forget that it wasn't always so nice. You know, I spent a summer in 1978 as a teenager working on a crew that was rehabbing a townhouse there. Honestly, I was a little scared coming to work every day. But what happened? You know, that neighborhood saw a lot of investment.
Thank you so much.
I'm sorry?
Time is up.
So, Mr. Chair, I'm just doing a pulse check to see if you'd like to continue in the vein of public comment, because we do have some people that indicated an interest to speak after our 12 noon cutoff as listed in the meeting notice. So with your direction, we'll proceed.
How many speakers do we have?
I'm looking at about 3 additional people.
Let's get them out of the way. Okay, so they don't have to come back. And
Paul Nichols.
Thank you much. I appreciate it. My name's Paul Nichols. I currently live in Latham. I'm a former homeowner and renter in the city of Albany. I currently own property on Colatasti Place, Chestnut Street in South Allen, and I've owned property in this city for over 20 years. In my opinion, the state's Housing Stability and Tenant Protection Act of 2019 already addresses most of the issues proposed in this set of laws. I really suggest those in favor of good cause read this legislation. For instance, there is already laws on the books for retaliatory eviction, which I hear keeps coming up. As a property owner, I can tell you the amount of legislation that's come through over the past 2 years has been unlike anything I've seen over the past 20 years. The challenge was with these laws, as has been laws in the past, really isn't really their initial intent, but rather who's going to be calling the balls and strikes out in the field. That said, today I want to briefly speak about two aspects of the proposed law, which I think are most concerning to the investment community. The first is, as many people have mentioned, is grounds for removal. With all due respect, I find it impossible to understand why a lease or contract that two consenting adults enter into is somehow considered not legally binding with respect to housing or a lease expiration. With proper notice, which is spelled out up front, why is one party allowed to violate the terms of a legal document? There are many reasons leases are not renewed. It's been touched on, things such as proposed unit renovations. And honestly, I have not spoken to one tenant, forget owners, who understand why this provision is being proposed. Similar to a relationship that doesn't work out, if one or both parties wish to end the relationships at the end of the lease, which they both legally entered into, then they should be able to do so. Keep in mind, tenants are our customers. We want them to stay. We need them to stay. I've never made money from an eviction. In fact, quite the opposite, and every landlord would tell you that. So if there's a non-renewal notice being issued, it's probably for a good reason. The second issue I just wanted to touch on was with respect to the rent limitation section. I can tell you with certainty that you will see multifamily housing in the neighborhoods that you all live in fall into disrepair, the opposite of the implied intention. Putting interior renovations aside, why would anyone put on a new roof, improve landscaping, or paint a building if they can't recoup their investment? You say this isn't for good landlords, but again, I'm concerned about who's calling balls and strikes. And lastly, I think you should know that I've personally received more calls in the last 5 weeks than I have in the last 5 years from people wanting to sell as a result of these proposals. And I think that says a lot about both perception and messaging with respect to this bill and investment in the city of Albany. Thank you so much.
Can I just interject? John Clarkson, John, didn't you sign up to speak last week? I'm sorry, folks. John.
John, you on mute.
Hey,
Yes,
John.
I did sign up last week.
Yes,
thank
if
you.
he could be given an opportunity, thanks.
Absolutely. I'm so sorry. That's completely my fault. My computer's frozen. So Mr. Clarkson, apologies extended. I'm so sorry.
No problem, Danielle. So I'm John Clarkson. I live at 61 South Lake Avenue, and I'm the president of the Pine Hills Neighborhood Association. Our association supports this package, F2I. We support protections for tenants and stronger measures to ensure good property conditions. All of these align with our focus on quality of life. The good cause eviction components, greater powers for the building department, and improved administration of ROPs and the dwelling registry are all good ideas. So we are supporting this generally. I'm going to have to put a couple of asterisks on that because we did this in a hurried fashion. We thought it was important to support this package, but we haven't yet done the full analysis. We usually have our zoning and code enforcement committee go through it at a very granular level. And so we we wanted to be here tonight to help support it. We could have more specific comments later. And the one component where we do have specific comments we want to give you tonight is on the modernize the dwelling registry and make for uniform administration and compliance of the ROPs. This is a very important component. We support it, but there's one thing we would really like to see, and that is for the city to send out a notice to landlords when they are coming up on an expiration of an ROP. You know, we want to support the good landlords. We've had a couple of people here tonight who gave good messages, and we want to focus more on the landlords that are not performing. And many of them may not even have an occupancy permit. So we would like you instead to focus on helping those folks. And if you are, you know, if this is your enforcement mechanism for the fundamental license or occupancy permit, it's worth notifying the landlords. It's worth keeping a good list. You know, every city employee who's out in the field, whether it's a building inspector, police officer, DGS, they should be able to see, look at that house, look at that building. Does it have an occupancy permit? How many? And if you made this information more broadly available, it would certainly help to enforce the fundamental requirement. So we support it. We may have additional comments, But I want to say a lot of what I'm hearing tonight, particularly over the good cause eviction, seems to be starkly opposed. Some of it perhaps misunderstanding about what is in the legislation. So I'm going to suggest that maybe Q&A is something to simplify and to answer the questions that council members and landlords are raising, because a lot of this may be simply misunderstanding of how the legislation would work. Thank you for the time to speak tonight.
Thank you. The next person I have is Betty Ann Benware. Nope.
I see a Rebecca Garrard also that indicated that they wanted to speak live.
Yeah, Rebecca. Is that it?
I believe that's it. I'm going through the comments in the chat. I don't see anybody else. I think that's it.
Okay.
Oh, no, there's Miss Garrard right now. She's entering. She's entering right now.
Wait, I'm here now. Can you hear me?
Yes, we can. Please state your name and address for the record. Right now, she's entering.
Yes, thank you so much. I'm sorry. I had trouble getting the Zoom. Rebecca Garrard. I'm here now. Can you hear me? Oops. Oh, hold on.
Please state your name and address for the record.
I'm sorry.
Right now, she's entering.
Yes, thank you so much. I'm sorry. I had trouble getting the Zoom.
Ms. Garrard, you may have to mute one of your devices.
Yeah, I was watching on Facebook. Forgive me. Yeah, 376 Madison Avenue, Albany 12210. Thank you for the opportunity to speak. I am here to speak in support of all of the housing legislation that is being proposed by the council. You know, I think I wanted to speak specifically about how much it was going to help the tenants of Albany who are really impacted by bad landlords and don't benefit from the development that comes into Albany, but instead are displaced by it. But I think I want to use the time that I'm allotted to kind of address some of the comments that have come up during this evening around why this might not be a good thing. You know, the reality is that if you're a good landlord, and I am a tenant now, but I used to be a landlord actually. If you're a good landlord and you have a tenant who fulfills lease obligations, who pays the rent on time, who takes care of the property, these are landlords who don't evict those tenants. That is absolutely not a thing. And so what we know about holdover evictions that are initiated without cause, is that they are utilized in two manners. One is in retaliation for complaining about conditions. And two, it is due to predatory rent increases that have nothing to do with investment in the property, but have everything to do with the fact that there's a proximity to development and resources, and are the result of gentrification of neighborhoods. And so we have disinvested communities that never, ever, ever get to benefit from investment because they're displaced by it. Those are facts. Those are literal facts. And so these protections that are being proposed will do nothing to hurt good landlords, nothing, but will do everything to make sure that every tenant in Albany who deserves to be a participating member and has a right to be a participating member of the community gets to do so in a really just and fair way. So I thank the mayor and I thank the council for their work on this and their due diligence and their recognition that housing is the epicenter and the basis for a stable community and a successful Albany.
Thank you.
We also have Vincent Raguso. I didn't see him. I did not call his name, so I apologize if he is with us and on the phone line.
Okay.
He left. I just called him. He gave up. He was hungry, he said.
Okay, that's it then?
That's all we have.
Okay, what I'm gonna do, I want to ask, we heard a lot of suggestions today. I want everybody to think them over, and I want to know what the sponsors want to do. Okay, I don't think we can take up 4 bills in one night, so let me know what you think about that.
Mr. Ballerin has his hand up.
Well, go ahead, Alfredo, I can't see it.
Thank you, Joe. I just want to address some of the issues that were brought up. One, I want to address the 5%. I want to re-emphasize, it's in the legislation. 30-328A. If improvements are made to a set unit or to a common area, that is a good reason to go beyond the 5%. So a common area would be a roof. That is a common area. That was brought up. If you put in a new kitchen, that is a common area. That is in the unit. That was brought up. So that is already in the document. I also want to clear up the issue where a tenant, you know, there's a feeling that a tenant can live for whenever you want. It is clearly put there that if you tell your tenant, hey, I'm going to renew your lease, are you going to renew? And the tenant says, no, I'm not going to renew. And you've given them sufficient warning, 5 months, and said, hey, you don't renew, I'm going to go rent it out to somebody else. And you find somebody else. That is a good cause for eviction. That is right there in the document. I get the fears. I get it, especially for landlords in a year where they have felt like they have gotten the short end of the stick, like I said before. You know, I get it. Yes, we were not eligible for any PPE. Yes, we didn't get any real benefits. We took all that ground, the hits after hits, and I get that. I do. But this legislation is not the same thing. This is specifically to deal with the fact that some landlords don't want to renew, not because you have a good tenant, because we all know if you have a good tenant, you're going to renew. And most times, if you have a good tenant, you're not going to raise the rent. And if you do, you're not going to raise it more than $50. Let's be honest. We know that. So what is this to address? This is to address landlords that don't want to renew and want to move tenants out because they are complaining too much. Let's be very blunt. So the person that's complaining about the tenant that's upstairs that plays the music all the time and that you're doing nothing about and calls you all the time, you don't want to deal with that person anymore. I'm going to put someone there who wants to play the music loud all the time. And then you force that person out. And that is the legitimate issues that residents are dealing with. That is not a made up story. That is a resident that I'm working with now, whose son is disabled, whose landlord does not deal with the other tenants in the building. And their fear, this tenant's resident's fear, is that the landlord will kick her and her family out if she goes to the city. It took months before she gave me her address. That's how afraid she was to lose her home. I understand these are people's investments and these are people's properties, but these are also people's homes. These are also people's homes. So there has to be a fair system. where landlords that are not being responsible, who are not doing their job, are held accountable. So I get the fears. I have no problem going through the legislation line by line if anybody wants to make sure people feel more comfortable and understand what the language is in there. Because there's a lot of fear being put out there to try to push this away. But if you read the legislation, if you understand the breakdown, this is going to help residents. And landlords who live and own in neighborhoods with other landlords who don't respect our community, you're gonna have a better block because it's gonna force other landlords to step up and do their job. So I look forward to the conversation. I look forward to going through line by line. If anybody wants to do that, to make sure people feel comfortable with the language that's in there, because it's clear. It is clear. I understand the confusion, and I understand we're not all lawyers. But if you read it, and I've read this several times, if you read it and you read it, you get to understand it better. Thank you.
Okay, Alfredo. We might take you up on that idea if people want, line by line. Sometimes that's the best way, especially in a more controversial piece like this. Yeah. So next we'll have Kathy, you're a sponsor. What would you like to do with yours?
Thanks. Thanks, Joe. I think it's important that we meet again on local law I. There are a lot of provisions that are contained in there, and there's some of them are very big changes. So I do want to give the public another opportunity to comment on
I
this
think we'll definitely have
and a discussion.
Okay. How about,
Thank you.
think we'll have to meet on each one of these pieces of legislation at least once more, maybe a few times on one or two of them. Okay, Michael O'Brien.
Okay, yeah, I think that the best solution is not to further discuss it tonight,
right?
But to plan on meeting in the future, perhaps local law by local law, because there are a lot of shared issues between them. But they're like, for example, there might be, like local law I don't see too many problems with.
Right.
That's my perspective.
Yeah.
So maybe the
Maybe we
ones
can take
that we
that
think
to
are,
another one and go from there. Yeah. Who
so
wants to go?
I'll leave
first?
it up to you, what order you want to consider.
No,
them.
I'm asking the sponsors. I think Richard wasn't here and that one's not, not that difficult, but
yeah.
Which one does the committee feel?
Yeah, I share the same sentiment. While there's a lot of support for local law H from residents and property owners, I think that further discussion is always good.
So why don't we put H and I together for a meeting?
Yeah, that works.
That sounds good.
Okay.
Okay.
So Danielle, if you could set up a meeting for those two, see when everybody's available.
Absolutely,
And
Mr. Chair.
Can we also set up a meeting for F, please? I don't want that to get lost.
Yeah, no, it's not going to get lost.
And I'll work with Corporation Counsel's office with F to go more in detail with that one.
If we could do one meeting for those two earliest time next week, possibly, and then the other one the week after that, the other, at least one more. Than Alfredo, you're requesting that first, so that sound reasonable to everybody? Okay,
Wednesday's a
Sounds reasonable to
possibility.
me.
next Wednesday? Okay. Is anybody else?
Public invited?
Of course. I'm sorry, I'm not the chair.
The public is always able to participate at the public meetings.
And I want to remind the public, okay, if you have any public comment, okay, we're going to be enforcing that deadline, which is when, 12 noon?
12 noon.
The day of the meeting.
Day of the meeting, okay?
And Chair, if I could just say, if there are some questions that you had that were not answered, just reach out to your council members. I always look forward to constituents, property owners. Just reach out. I will get an answer for you. Some people might not like it, but I will get you an answer. So don't hesitate to reach out to your council members on any of the issues moving forward.
And I don't know about the availability, how you want to handle like Bob and Laura, if questions come up.
Yeah, we're available in the meantime, and I think we can make the meetings as well.
Yes, absolutely.
That's great. So Danielle, do what you can with that, all right? I'm available.
Absolutely. I'll send an email out tomorrow with some available dates that will allow us to do our meeting notice within the 7-day as required.
Okay. I'd just like to thank everybody and all the public for taking the time to sit down, make the comments, the great suggestions, and just stay involved. Thank you all.
Thank you.
I'm
Good
sorry.
night.
Motion to adjourn.
Have a good night, everybody.
Okay, that's it.
Second.
All those in favor, aye.
Aye.
Good night.